Okay, good afternoon, everyone. Welcome to the National Conference of State Legislatures, first of a three-part meeting series on policing policy, hosted by the Law, Criminal Justice, and Public Safety Committee. My name is Lucia Bragg, Senior Policy Specialist, staffing NCSL's Law, Criminal Justice, and Public Safety Committee, and I will be your moderator today. Before I introduce our speaker, I want to go over just a few logistics for this briefing. For now, everyone is on mute. I encourage you to ask questions as we go using the chat box, which is either on the right of your screen or is accessible by clicking on the word bubble symbol in the navigation bar at the bottom of your screen. NCSL staff on the line will collect questions for Q&A, and our presenter will respond at the end of her presentation. This meeting will be recorded and posted on NCSL's YouTube page for future reference. And once our speaker begins, NCSL staff will periodically enter related resource links into the chat box for your reference. Today's slides will also be posted online, as well as the recording. So without further delay, I will pivot to today's program. The nation has witnessed a powerful series of protests across the country in recent weeks in response to the death of George Floyd while in Minneapolis police custody. These recent protests have generated federal and state interest in examining and revising police practices. And this series is meant to educate and inform state legislators and legislative staff across the country who work on policing issues in their states. So today, we will discuss federal law enforcement statutes and case law, specifically federal laws governing qualified immunity for law enforcement officers, the use of force and duty to intervene, and indemnification issues. Our speaker today is Lisa Sornin, Executive Director of the State and Local Legal Center, or SLLC. In this role, Lisa files amicus briefs to the United States Supreme Court on behalf of members of the Big Seven state and local government associations. I won't list them all, but many of you are familiar with them, in cases affecting state and local government in particular. Prior to joining SLLC, Lisa worked for the National School Boards Association, the Wisconsin Association of School Boards, and clerked for the Wisconsin Court of Appeals. She earned her JD at the University of Wisconsin Law School and is a graduate of Central Michigan University. Lisa, the floor is yours.
Thank you, Lucia, for that kind and welcoming introduction. I have to tell you that when I got this job, as Lucia mentioned, my background was in school law, and I was thrilled at the idea of doing police cases because I knew they would be juicy. And of course, in schools, that police issues were a small part of it, but very, very little. And I have worked on a number of police cases at this job, but the reality is that most people don't think a lot about the policing and the legal issues related to it. And so I have really mixed feelings about this topic because, as Lucia points out, we're talking about this topic in difficult times in our country. But on the other hand, it's a keen interest of mine and something I've worked a lot on. So I'm happy to share what I know with you. So this is an overview of what I'm going to talk about. I'm going to discuss what excessive force is as defined by the United States Supreme Court. I'm going to explain qualified immunity. I'm going to talk about some attempts going on right now to change or get rid of the qualified immunity doctrine. I'm going to talk a little bit about indemnification, which is not an easy word to say. And I'm just going to pose some questions to you all as policymakers to think about as you contemplate what you think should happen with qualified immunity. So to understand qualified immunity, you have to understand Section 1983. One other favorite story of mine was I didn't learn about Section 1983 in law school, and I remember as a young lawyer going into a colleague's office and saying, "What in the world is Section 1983? It's a vehicle for bringing lawsuits? That doesn't even make any sense." But that's exactly what it is. It's a vehicle for bringing lawsuits by citizens against state and local government officials for violating constitutional rights. Qualified immunity is a defense to Section 1983. So you can almost think about them as two sides of a coin, that it's Section 1983 that allows a lawsuit and qualified immunity that gives a defense. So here's the text of Section 1983. I'm not going to read it, but basically it says that government officials, or that Section 1983 makes government officials and employees liable for money damages if they violate a person's federal, constitutional, or statutory rights. And Section 1983 was adopted in 1871. It was a response, basically, it was part of the Ku Klux Klan Act. It was a response to the fact that a great deal of violations were happening and nothing was being done. There was no prosecution, there was no action on them. So a specific claim in federal court was made for constitutional violations by state and local officials. So that is its beginning. So like I said, qualified immunity is a defense to Section 1983 claims. If it applies, local governments cannot be successfully sued for money damages. And it's important to note that qualified immunity, or rather I should say, Section 1983 applies to individuals, doesn't apply to state and local governments. You are suing an individual in their individual capacity, but as a practical matter, state and local governments almost always pay the damages, which I'll talk about more later. So that's why it's so important to state and local governments, even though they're not actually ever being sued under Section 1983, they're the ones who are financially responsible. So the use of force can be a violation of the Constitution. And the violation is found in the Fourth Amendment, and excessive force is considered a violation of the Fourth Amendment's prohibition against unreasonable searches and seizures. And it's just important to note that excessive force does not have to be deadly, and not all deadly force is considered excessive. So this might surprise you, that there are only 4 Supreme Court cases that define what excessive force is. And only 2 of them really lay out a legal standard. The other 2 more or less modify and clarify the standard. And in only 2 cases is the standard actually even applied. And probably the most important thing I'm going to say in this presentation is that excessive force is not a bright line rule. And reasonableness is sort of like the capstone. That's sort of the test under the Fourth Amendment for everything. And so with 4 cases, it can be difficult to know sort of exactly what's going on. So Tennessee versus Gardner is the first Supreme Court case. And in that case, the court held that deadly force may not be used to prevent a person from escaping unless that person poses a significant threat of death or injury to the officer or to others around. So what happened in this case is that there was a robbery suspect who was getting away on foot, jumping a fence, and the police officer shot the person. And this is what's interesting. Tennessee law and the policy of the department basically allowed the use of deadly force in burglaries and allowed the use of deadly force for anyone who is fleeing arrest for any reason. So Tennessee basically argued, if probable cause exists, we can seize someone any way we want to. But the court said, no, the Fourth Amendment has a balancing test. It's based on reasonableness. You can't just seize someone any way you want just because you've got probable cause to arrest them. So like I said, the bottom line holding was that if you're unarmed, undangerous, you can't be shot. But the court did say, if you were escaping and you posed a risk to the officer or to someone around, then the use of deadly force might be appropriate. This is a 6-3 decision, and this is something interesting to think about. Before 1985, if a state had the common law rule, if there was a fleeing felon, so he had to have committed a felony, under the common law rule, any amount of force could be used to stop that person for any felony. I mean, kind of crazy, right? 1985, not that long ago. Okay, so Graham versus Connor is the case that came after this. And like the technical legal holding says that the Fourth Amendment standard that's going to be used is one of objective reasonableness rather than substantive due process. I know this sounds kind of technical. The facts of the case are kind of wild. Graham was a diabetic. He asked a friend to take him to a grocery store or a convenience store to buy juice. He saw the line was long and he left. And an officer saw him leave and wondered why he left so quickly. So the officer pulled the car over. The friend said, look, my friend's a diabetic. He needs something to drink. And the officer said, well, I'm going to look into that, so hold tight. And Graham, for whatever reason, got out of the car, ran around it 2 times, and passed out. So a bunch more officers came up. arrived at the scene, and they ended up throwing Graham in the car and throwing him on the roof of the car. Then the officer ultimately found out, oh, he wasn't doing anything bad at the gas station, so they let him go. And he said this was excessive force. So like I said, the important holding is that the court said excessive force will be done under the Fourth Amendment, and it will be a reasonableness standard. It won't be substantive due process, which would be more favorable to the victims. The court also talked about the balancing test and said, here are the specific factors we're going to look at: the severity of the crime, does the suspect pose an immediate threat, and are they essentially resisting or evading arrest. So these are the principles that kind of came out of the case. Every time you see a lower court decision on qualified immunity or on excessive force, you see these three quotes. They're always in there. And what they basically say is, officers can use reasonable force. We have to look at police officers from the perspective of someone who's making a split-second decision. Hindsight is not the right way to look at these interactions, but those are the cited lines in every sort of court opinion. So this decision was unanimous, and it was also the first time the court used the word excessive. I'm sure you noticed it wasn't a deadly force case, and in fact, the court didn't even decide if the force in this case was excessive, but it solidified the idea that excessive force cases are under the Fourth Amendment. Scott versus Harris applies Graham versus Connor. This is a fleeing motorist case, and the court basically said if you're a fleeing motorist and you continue to endanger the lives of others by fleeing, a police officer can ram your car, which is basically what happened in this case. Scott had led officers on a long high-speed chase over on two-lane roads. And ultimately, the officer called a supervisor and said, can I just use this maneuver and like hit him to disable his car? The supervisor said yes. When he used the maneuver, he did it wrong. And it basically caused the car to turn over multiple times. And Mr. Harris became a paraplegic. And so here's the thing about this case. Harris did not pose an immediate threat to the officers at the time, or Scott rather, didn't pose an immediate threat at the time that Officer Harris hit him. And so the question was, could excessive force still be used? And Justice Scalia wrote the opinion, basically said, Garner isn't an on and off switch. We have to look and see if the actions were reasonable. Is it reasonable for officers to do something that might kill or injure someone when there's a higher probability that they're going to kill or injure someone than letting this suspect go, the probability of the suspect killing or injuring someone? And basically Justice Scalia said, it's kind of a matter of who's culpable. And this guy, ran away from the police, so he has some culpability here. And the court also said police officers are not required to stop car chases. So the most interesting thing I find about this case, other than the fact that, like I said, technically I don't think it really meets the Garner standard, which I guess is a looser test according to Justice Scalia, huge gap in time between Graham and Scott, a decade and a half. Interesting, right? 8-1 decision. Only dissenting was Justice Stevens. The other thing is video evidence was relevant in this case, which was interesting sort of in and of itself. The only case that I worked on, or I've worked on so far, is the Plumoff versus Ricard case. This is kind of a follow-up to Scott versus Harris. And again, the police officer said that the use of force in a high-speed chase was all right. Basically, Mr. Ricard was being pulled over for having a headlight out. He took off. He led the police officers on a long high-speed chase, crossing 2 states, going over 100 miles an hour. He ultimately was kind of cornered by the police. And when he was shot, he was kind of revving his engine and pointing his tires to leave. And even after he got shot, he continued to leave until he was shot more. And so the question was this excessive use of force? The Supreme Court basically said this is kind of the same thing as Scott versus Harris. The fact that the officer shot a lot of times doesn't matter. If your goal is to sort of end his escape, you have to end it, whatever it sort of takes. The opinion was also unanimous, but Justice Breyer and Justice Ginsburg didn't join all of it. It was a very short opinion, and the court also said, even if the force hadn't been reasonable in this case, but it was reasonable, qualified immunity would apply. So here are my overall observations about the use of force precedent. Like I said, it's crazy to think in 1984, a police officer could have done anything they wanted to stop a fleeing felon. I think the reality is that the excessive force is standard is fairly deferential to law enforcement as long as the safety of an officer or others is at stake. And that's a big as long as. It's interesting too, the court has never taken a case, an excessive force case, where there were any issues of individual racism. Like I said, very little Supreme Court precedent on this. So this is what this all means. The Supreme Court's views of this topic, of course they matter because the Supreme Court sets a framework, but the reality is the views that really matter are the circuit courts of appeals. These circuit courts of appeals are going to be hearing tons of excessive force cases every year. I want to make this point that excessive force is not a free pass. And I went through some case law just to give you kind of some examples. Too tight handcuffs has been held to be excessive force. Handcuffing someone in the back, like if they have a broken arm, excessive force. Pointing a loaded rifle at someone, just to sort of show, I don't know, that you're in charge, that can be considered excessive force. Here's one that's sort of current for our times. Pepper spraying nonviolent and unarmed protesters, considered excessive force. Pepper spraying people to cause pain, excessive force. Tasing a drunk driver, the lots and lots and lots of taser cases. And the last case is one that made national news. Individual programs, this is the Armstrong case. This poor guy, mentally ill at a hospital, had left the hospital and like didn't want to go back. And within minutes, officers had tased him, I don't know, 5 times. And they used like a function of the taser that you're not supposed to use for someone who's like compliant, and he died. And so courts are, like I said, not all force has to be deadly for it to be excessive. And I do think courts are sympathetic of people who are in police custody and expect police officers to act reasonably. And I think these cases are somewhat of an illustration of this. There's been a lot of interest in the duty to intervene. And, you know, a la the George Floyd killing, because there were all those officers standing around watching what the officer in charge was doing. There is a cause of action for excessive force, duty to intervene. There's a couple elements that have to be met. First, you have to observe the excessive force. I mean, I would think obviously. And then you have to be reasonably able to prevent it. Like, so one example is like, let's say a police officer punches someone in the face in front of his colleagues, but the officer doesn't do anything after that. Well, you can't stop really the first punch, but you can stop any punches after that. So one thing that's sort of interesting about this is, does equal rank or lower rank matter? Like, what if you are the junior officer and you're the one that can intervene? I have not read any cases that make any distinguishment between being a junior officer and not having a duty to intervene. It might be out there, but I just wanted to point that out. I don't know that every Federal Circuit Court of Appeals has had a duty to intervene case and said that the cause of action exists, but many have. Here on the next slide, I have a whole bunch of examples. And so remember, once a Court of Appeals has said there's a duty to intervene, then that duty is clearly established. And so there's no qualified immunity to get you out once it's established that there's a duty to intervene if you see excessive force and you are reasonably able to stop it. So like I said, a lot of cases in this space. Okay, so now we've talked about one side of the coin, and that is the Section 1983 excessive force side. Now let's move to the qualified immunity side, which is the defense side. So one thing that's really controversial about qualified immunity is that it is not contained in the statute. If you read Section 1983, no matter how many times you read it, you're never going to see anything about qualified immunity. It was created by the United States Supreme Court. The modern test for qualified immunity, and it's changed over time, is that qualified immunity is generally available if a law enforcement official violated law that isn't clearly established. So Harlow versus Fitzgerald established that in 1982. So what does clearly established mean? Well, it's very favorable to government. My favorite one is probably the second one. Qualified immunity protects all except the plainly incompetent or those who knowingly violate the law. So if a law is not very clearly established, as defined by these criteria, it's not clearly established. So qualified immunity applies to all state and local government officials in all their interactions. But the reality is that most of the controversy over qualified immunity has focused on qualified immunity's use when police officers use force. And so here's the deal. It is possible that a police officer could be found to have engaged in excessive force, but qualified immunity will protect that officer, meaning no money damages are required, if the use of force at the time it happened wasn't clearly established. So this does not seem fair to many people. They think, are you kidding me? This officer violated the Constitution, but there's no liability for him or her. And that doesn't sit well with people. But the other side of it is this. If the officer violated the Constitution, but no court had said that under facts like this, there is a constitutional violation, is that really fair to the officer and the state and local governments that ultimately pay the money damages? So that's the argument. And I'll just give you an example. Think about Monday. On the Supreme Court, on Monday, the Supreme Court said transgender and gay employees have rights under Title VII. So as of Monday, those rights were established, right? Now, it's not the Constitution, but you get what I'm saying. So before then, other than in a couple federal circuits, like no one knew that these rights existed and believed that they in fact didn't exist. So would it be fair to sort of like hold someone liable for engaging in behavior that was never articulated to be unconstitutional until a court heard it for the first time? So that's one of the defenses for qualified immunity, is it gives fair notice to government officials and their employers who pay the damages of what they can and can't be sued for. Now, the Supreme Court in Harlow versus Fitzgerald also went through other policy justifications for qualified immunity. It saves officers and other government officials the expense of litigation, the fact that they don't have to focus their time and their energy on litigation. Also, it maybe will prompt people to want to participate in public service because they know that if they make a mistake and it's a reasonable mistake, that they'll get qualified immunity. And the other justification I think is interesting. I think the strongest justification is the fair notice. Like, why should I be responsible for conduct that I didn't know was unconstitutional? But the second one, in particular in the police context, is the idea that a police officer may hesitate without qualified immunity. And maybe in a tense situation where things are rapidly changing and not want to use force, thinking, oh, I might be violating the law. And as a result, the officer will be harming themselves or someone around them will be harmed. And qualified immunity is supposed to stop that from happening. I also want to say too, if the law is clearly established, there is no mercy. Like, the police officer is going to get it, or anyone else is going to get it. And this case came out a couple days after, maybe about 2 weeks after George Floyd was killed. And basically the court said, look, it's very clear that, 7 years ago, we said you can't shoot someone 22 times in the back when they're lying on the ground not doing anything. So it's pretty clearly established, that the force was excessive in this case. So like I said, once it's clearly established, you're sort of done. So I'm just going to give you an example to kind of show how qualified immunity and how Section 1983 work kind of in tandem. And Mullocks versus Luna is a very interesting case. The Supreme Court decided it per curiam without oral argument. So basically this officer was going to go arrest this guy. And the guy took off, led the officer on about a 20-minute car chase. And interestingly, he kept on calling the police department and saying, I have a gun, it's right next to me, and if I see any police officers, I'm going to kill them. So he did that twice. So police officers got way ahead of this guy, and they're putting up spike strips to stop the car. So an officer called his supervisor and said, I think I want to just shoot this guy's engine and see if that works. And the officer claimed he didn't hear his supervisor's response, but the supervisor basically said, don't do that. Like, just wait and see this, if the strips work. Anyway, doesn't listen to a supervisor he claims he doesn't hear, and he ends up shooting the car. So he shoots the car repeatedly, and he never hits the engine block, but he does shoot the guy, I don't know, multiple times, and he does die from gunshot wounds. So the question in this case was whether or not there was excessive force. And the court said, you know, we're not going to decide that. We're just going to decide whether or not there's qualified immunity. And we're going to say, well, it wasn't beyond debate that this guy's actions were, this police officer's actions were unreasonable. After all, this guy might have been drunk. It was a 25-mile police chase. He was threatening officers, and there was an officer down below putting out the spike strips, which to me, like, that doesn't make a lot of sense to shoot. But the point is, like, the guy driving the car would see him and then maybe want to shoot him. But this case was somewhat controversial. So Justice Scalia, who was alive at the time, said, look, I mean, there can't be any excessive force here. There was no intention to shoot and kill this guy. But Justice Sotomayor dissented and basically said, like, this is crazy. And from a government employer's perspective, what's kind of interesting is that this police officer did not listen to his supervisor, who told him not to do it. And he didn't even wait to get a yay or nay. So now to put all this qualified immunity and excessive force into some context. So long before George Floyd's death, qualified immunity was under attack from both the right and from the left, and from academics, from judges, from Supreme Court justices, and even from presidential candidates. I would say, I think it was March of 2008 when it came to my attention that qualified immunity was under serious attack, when I went to a seminar on it. And like I said, tons of people have been attacking it. Part of the reason why it was being attacked is that the Supreme Court track record for qualified immunity for local governments and state governments as well is really good. In only 2 cases since 1982 has the Supreme Court said that police violated clearly established law. And in the last couple of years, the Supreme Court kept on accepting cases where the lower court had denied qualified immunity, and then the Supreme Court, without oral argument, would grant the petitions and then say, this court denied qualified immunity when they should have granted qualified immunity. So that's part of the reason why the doctrine's been under attack. It's also fairly favorable to state and local governments. I mean, remember, beyond debate, only clearly incompetent people. You know, that's the sort of standard. And here's some of the Supreme Court cases where they reversed denials of qualified immunity. So like I said, for about 2 years, there's been trouble brewing on the qualified immunity front in front of the Supreme Court. On Monday, the Supreme Court had 9 petitions in front of it. And some of those petitions asked the court to either overrule or modify the doctrine. And the court had been sitting on some of these petitions since October. So many of us thought the court was gonna accept one of these cases. So the court ultimately denied cert in all of the cases. And of course, we don't know why. But I do think the decision was made before George Floyd was killed, because they first heard all 9 of these cases at a conference in middle of May. And presumably they were waiting to deny all the petitions because Justice Thomas wrote an opinion disagreeing with the denial of cert, saying basically we should have heard these cases. But on a practical level, I think there are probably only 2 justices that are willing to eliminate qualified immunity, and that's Justice Sotomayor and Justice Thomas. So even if there were 5 or more justices that were willing to modify it, there may not be any consensus within those 5 justices of how to modify it. So why take a petition if you can't do anything with it? So a reporter asked me, like, well, are they ever going to do anything with it? And I said to the reporter, well, remember the Hillary court? That was the imaginary Supreme Court that Hillary Clinton was going to appoint when she became president. And it was going to have 7 liberals and 2 conservatives. That court, if it ever happens, under a different president's name, of course, may do something with qualified immunity. But the current court is sort of, unwilling to do it at this point. So as most of you know, probably, the culmination in Congress is this. So first, Congress can get rid of qualified immunity. With the stroke of a pen, they can get rid of it. So the Justice in Policing Act, this is the act proposed by the House Democrats. It would eliminate qualified immunity for state and local police and corrections officers. Now, the Justin Amash Ending Qualified Immunity Act, this is in the House, it would eliminate qualified immunity for all state and local government employees. So big difference between those two bills. One just focuses on police, and the other one focuses on all state and local government employees. On the first one, I was very curious to see before it came out, was it just gonna focus on police use of force, or was it gonna focus on police in general? Focuses on police in general, because remember, police officers get sued for false arrest under the Fourth Amendment, they get sued for First Amendment violations, but in the first one, doesn't matter. No qualified immunity to police officers, period. The Senate Republican police reform bill that came out today does not eliminate or modify qualified immunity as far as I can tell. So I'm going to wrap up talking a little bit about indemnification and then some policy questions. So indemnification is basically near absolute. A professor called Joanna Schwartz did research, an article that came out in 2014, and she studied all sorts of judgments against police officers and discovered that basically 100% of the time, the state or local government reimburses the person, the police officer, the other government official. The reason for that is because often state law requires it. But of course, if those state laws were repealed, then individuals would have to pay themselves unless local or state governments decided on their own, which might make attracting employees sort of difficult. So a lot of talk about what might be the consequences of qualified immunity going away. Here are what I think the consequences will be. There'll be more excessive force lawsuits. I mean, it's as simple as that. I heard one guy say every time a police officer uses force, there would be then an excessive force claim. If you think about it, qualified immunity is like a hurdle to bringing an excessive force claim, right? Once that hurdle is gone, why wouldn't you bring a claim? They'd be more successful lawsuits. And I think the reason why is, again, a lot of lawsuits are kicked out on qualified immunity. I think that some local governments could face difficulties getting insurance. Might be harder to self-insure, especially at the beginning when it would be like unclear what the judgment sort of might look like. I don't know whether officers would really hesitate if they didn't have qualified immunity in intense situations. That's one of the theories. I don't know if it would really sort of play out. And here's another thing, would officers use less excessive force? I mean, it's certainly possible. The truth is, I don't really know. So Joanna Schwartz hates qualified immunity. And she's also written about what she thinks the world would look like without qualified immunity. She thinks that the rights wouldn't change significantly, but she does agree that if there was no qualified immunity, at least conservative judges would be probably less likely to find excessive force. She thinks success rates among lawsuits would stay about the same. I disagree with her. She thinks lawsuits would be less complex. They would be because qualified immunity wouldn't exist anymore. Also, like her last point, like literally makes me laugh. She said, well, indemnification will still shield government entities and officials. It'll still shield government officials, but it won't shield government entities. They either have to pay themselves or through insurance. So as we wrap up, I think these are some of the questions that are worth thinking about. Is it really fair to victims of excessive force that they may receive nothing if there was a constitutional violation, but it wasn't clearly established? Is that really truly fair? And I think the short answer to that is no. And we could live in a world where there was a system like workers' comp. For example, if I fall down the stairs at work, or one of my colleagues pushes me down the stairs at work and I get injured, I could file a workers' comp claim. Fault doesn't sort of matter. We could have a system where if you were injured by the police, whether it's your fault or their fault, you could get money damages. That it's just the cost of doing business is having police officers, bad things are gonna happen sometimes, everyone would get something. I also just wanna point out that sometimes local governments pay and state governments pay anyway. The Michael Brown case is a good example. I'm not familiar with every detail, but it's doubtful to me that the force used in that case would have been considered excessive. Even if it would have been considered excessive, qualified immunity probably would have applied. Nevertheless, that local government paid his family money damages. So money damages, they're not necessarily owed, but sometimes they're paid anyway. But the flip side is, like I said, is it really fair that police officers are financially and morally held responsible for doing unconstitutional things that no one told them or could have told them until they were told were in fact unconstitutional? And then, like I asked the question, I think this is a really important question. Like, would officers hesitate if qualified immunity went away? If they would, it's a really serious thing to sort of think about. I think an important question is also, is there any way qualified immunity could be modified that's both fair to officers and the victims rather than eliminated? I think the difficulty with that is that, you know, the clearly established test, like, what is really an alternative to that? Like, rack your brains. It's hard to come up with something other than that. Another question I think too is that you have to ask yourself, like, would eliminating or modifying qualified immunity really actually cause officers to engage in less excessive use of force? It may or it may not. Like, qualified immunity may not be the reason officers are engaging in excessive force. So getting rid of it may not stop it. And a related question is this. Let's assume, I do assume, that more people of color have excessive force used against them. So to the extent that eliminating or modifying qualified immunity would cause less people of color to be victims of excessive force, it would create more racial justice. That's a pro. But again, it assumes that qualified immunity is one of the reasons officers use excessive force, which I don't think is necessarily the case. And then I think, you know, with these defund the police conversations, I think, you know, a big question is, do we need more social workers and less police? So I always end my discussions about qualified immunity by telling this story. And so my brother-in-law sent me this article a couple of years ago. I don't think my brother-in-law has any idea what I really do for a living. I certainly don't think that he knows that I help defend police before the Supreme Court. But he sent me this article. And I'd recommend that you all read it because it just illustrates like the surprise, the complexity, and the heartbreaking nature of officers' use of force. So the officer in this case was 25 years old, and he was called at like 3 o'clock in the morning to meet a young man. And the young man was armed. He was told he would be armed. And the girlfriend of the young man told the dispatcher, my boyfriend is suicidal. He wants to be killed by a cop. He's trying to get suicide by a cop. He has a gun, but he doesn't have any ammunition in it. Like it's completely out of it. The dispatcher does not convey, the dispatcher says watch for a gun, but doesn't convey the information that the guy's suicidal or that he doesn't have any bullets in the gun. Anyway, so the officer says, I don't want to shoot you, brother. He keeps on saying to the guy, like, I don't want to shoot you. I don't want to do this. So a little bit of time passes, and other officers had heard that this guy was responding to this episode. So 3 officers show up. And when they show up, the guy is ultimately the victim, ends up like raising his gun and pointing it in the direction of the first officer. But he says he's pointing it too wide. So if he would have shot him, it was pointed at his torso, but too wide. So he would have missed him. Anyway, all his colleagues scream, put the gun down, or we're going to shoot you. You won't put the gun down. And one of the officers shoots him and ultimately kills him. So what happens a couple weeks later is one of the officers is fired. And the officer who is fired is not the officer that shot. It's the officer that didn't shoot. And so like I said, it's a surprising, complex, heartbreaking story that illustrates all the, or not all, but some of the complexity that is in this strange world of excessive force and its partner in crime, qualified immunity. So if you have any questions, I'm gonna now try to figure out where they are.
Thanks, Lisa. Just to transition us here, thank you for that excellent presentation, as always. We will now turn to Amber Widgery with NCSL's Criminal Justice Program for questions that she's gathered from the chat box.
Thanks, Lucia, and thank you, Lisa, for that presentation. The first question we have is really distinguishing sort of between 2 standards. Can you maybe walk us a little bit through objectively reasonable and also clearly established and the relation between those 2 standards?
Okay. Okay, so the objectively reasonable attaches to the Fourth Amendment. So that the objectively reasonable is part of the standard that you would use to sue for excessive force. I guess objectively reasonable might also play into qualified immunity as well, but the reasonableness standard is more a part of the Fourth Amendment. So when a court is looking at excessive force, they're saying, was this use of force reasonable? That's always the criteria. Was this search reasonable? Reasonable, reasonable, reasonable. That is the sort of bedrock principle of the Fourth Amendment. So clearly established attaches to qualified immunity. And then the question there is whether the legal violation, the violation of the law, was clearly established. So to use George Floyd as an example, was it clearly established that standing on someone's neck for 8 minutes who wasn't fleeing and was lying on the ground, is it clearly established that that is excessive force? So in probably every single federal circuit, that would be clearly established. How that would relate to the Fourth Amendment would be like, was it reasonable for the officer to stand on someone's neck for 8 minutes who was lying on the ground? No. So what you'd have in that case, I kind of did it backwards, is a violation of the Fourth Amendment. It is not reasonable to stand on someone's neck for 8 minutes, and qualified immunity. Some court some time ago, maybe not talking about standing on the neck, but would have said like, you can't suffocate someone or kill someone who isn't fighting you. And it poses no danger. Even if you go back to Gardner, you know, that this use of force wouldn't have been appropriate. It's a lot of terminology, a lot of legal words, but reasonable is the Fourth Amendment standard, clearly established is the qualified immunity standard.
Okay, and then this one, the first question is whether you're familiar with the Monell case, and then whether that case allows for person to include entities under Section 1983. And
Okay.
if you answer that question later.
So my understanding of Monell is that Monell allows like the employer to be liable, but there has to have been a pattern or practice. So a lot of times when you have, and again, George Floyd provides a good example, probably what the Minnesota Police Department would say is we unequivocally and absolutely do not have a policy that allows chokeholds, certainly not a chokehold for that long, certainly not of someone who is on the ground. So we cannot be sued because we don't have a pattern or practice of this behavior. So that's how Monell liability comes into all this. Monell is like the case, is the case that would allow or disallow, depending on the case may be, for the government entity to be sued. But it's a pretty high standard to me. I mean, there has to be that the law enforcement unit, the actual entity, had a pattern or practice of like this obnoxious, awful behavior, whatever it might be.
Okay, next question. Would changes to qualified immunity also impact prosecutorial immunity?
So that's a really good question. I would say no, because the Supreme Court has sort of carved out those immunities as being separate, and the prosecutorial immunities, I think, basically absolute immunity. But again, like the Supreme Court could get rid of absolute immunity, and Congress could get rid of absolute immunity as well. I've seen the argument made, though, that if the Supreme Court got rid of qualified immunity, that like some of the precedents that are like the precedents for qualified immunity are also the same precedents as for absolute immunity. So like kind of like would the whole house of cards crumble? I think the short answer is the whole house of cards wouldn't crumble on one day, but it could sort of ultimately crumble. Those immunities are related, but they're separate. So I would say like if the court or if Congress got rid of qualified immunity, I'd be worried, but I wouldn't assume that the other immunities didn't exist.
Okay, next question. You noted on one of the slides that Justice Thomas isn't as supportive as some of his conservative colleagues on the Supreme Court. Why is that the case?
Yeah, so it's really interesting. The reason that Justice Thomas has articulated for being skeptical of qualified immunity is, as I mentioned before, if you read the statute, section 1983, it says nothing about qualified immunity. And the court read in qualified immunity into the statute in 1967. And so the argument that the court made in 1967 was like, look, there were a bunch of good faith defenses. You know, if you were accused of violating the Constitution in 1871, you could have still brought up a bunch of defenses. So from that, the court sort of morphed that into qualified immunity. And Justice Thomas says, well, I don't think there were that many defenses available in 1871. And even if there were defenses, clearly established wasn't a part of the calculus at all. So qualified immunity is essentially something that the court, dreamed up for kind of no good reason. That's his thinking.
Somewhat related, you also noted that even the more liberal justices have generally favored qualified immunity. Why do you think that has been the case?
Yeah, I mean, look at the holding of Scott versus Harris. Look at Plumhoff. I mean, either unanimous or near unanimous. I think that the court and the justices are genuinely concerned about police officers having difficult jobs, making split-second decisions. I think they really hold those principles dear. And I think that their favoring of police officers is just a reflection of that. Justice Sotomayor has just sort of taken a different tack in a number of decisions. She's, I think, more frustrated by racial discrimination and discrepancies and inequities. And I think that somewhat fuels her thinking. But, you know, the differences between the liberal justice on most issues is very, very small. And they have, you know, largely been very supportive. Another thing I'll just mention on that note is that there's as the Supreme Court term sort of comes to an end, we're kind of getting to know Justice Kavanaugh better. He was only on the court for 1 year so far. He didn't have a lot of big decisions. There wasn't a lot of big decisions this term. He split with Justice Roberts and the transgender sexual orientation cases. And so, you know, curious to know his views on some of this stuff. When he was on the DC circuit, he wrote just a glowing opinion about the significance and importance and validity of qualified immunity in a false arrest case. So, you know, that's more the stalwart conservative kind of view.
Okay, thank you so much for that, Lisa. And I don't see that anyone has submitted any additional or final questions. And so with that, I would like to highlight that Allison did add a link in the chat to our new NCSL pending legislation database. So wanted to make everyone aware of that. And I will now turn it back over to Lucia.
Excellent. Thanks so much, Amber, for those excellent questions, and for everyone for those excellent questions. And thank you again, Lisa, for an excellent presentation. We just love having Lisa on. She's so knowledgeable, and she's a constant resource. So if folks have you know, questions later on or anything, you know, we can always connect you. And we're running up against the hour here, so I will just say as a reminder, our next policing briefing will take place on June 30th at 3 o'clock Eastern, and it will cover recent congressional legislative developments on policing. So our third program, it's worth mentioning too, occurs on July 15th at 3 o'clock Eastern, where we will discuss recent state legislative action on this issue. So with that, thanks everyone for joining, and thanks to the staff, and thanks again, Lisa.